In the Circuit Court for Dixon County, Tennessee, at Charlotte, September term, Grand Jury 2024. The grand jurors of Dixon County, Tennessee, duly impaneled, sworn, and upon their oaths do present that on or about July 24th, 2024, in Dixon County, Tennessee, and prior to the finding of this indictment, Shereef Markee Vaughn, then and there, did unlawfully and knowingly fail to appear in the Circuit Court for Dixon County, Charlotte, Tennessee, as directed by the Circuit Court for the purpose of attending an official proceeding, to wit, trial date for docket cases 22 CC 2022 CR 336, 2022 CC 22 CC 2023 CR 227, and 2022 CC 2021 CR 462 in violation of Tennessee Code Annotated 3916-609 and against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, to that indictment, how do you plead?
Not guilty, Your Honor.
Plea of not guilty is entered. The next step will be for the opening statements of the lawyers or of Mr. Vaughn, if you choose to do so. General?
Judge, I'll waive an opening.
Mr. Vaughn, do you wish to make any sort of opening statement?
No, sir.
All right. Opening statements have been waived. Therefore, the state may proceed with its proof. You may call your first witness.
State will call Pam Lewis.
Ms. Lewis, if you'll come forward, please.
Are you Pam Lewis?
Yes, ma'am.
And you are our Dixon County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your staff are present for all circuit court dates.
Yes.
And in this case, we are here, Shereef Markee Vaughn is on trial, and we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dixon County?
Yes, it was before Judge Lockard Mash.
And he needed to appear in the same courtroom that on July 19th as he was on July 24th?
Yes, ma'am.
And was his court date announced on that July 19th date?
Yes.
Now, would he have known about the trial date before that July 19th date?
Yes, he was notified in March of 2024 when Attorney Flanagan filed a motion to withdraw his counsel.
So he was aware of the court date in March and then was in court, let's see, the 19th to the 24th, 5 days before his trial date.
Yes.
Now, on the date of a trial, such as the one scheduled on July 24th of 2024, does your office bring in a jury panel?
Yes, ma'am.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Okay. I believe you just stated to Ms. Bryson that your job title is to maintain court records.
Yes, sir.
Okay. What type of records are they? Like?
We have criminal records, civil records.
Okay. Okay, are you biased against me?
No,
You are not?
no.
Okay. Do you recall, speaking to, are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
Okay, I don't have it with me. I have, on some of your records, it says that, you spoke to, Scott Tummins and as well to, Lee Spratt. You not recall your record saying that?
No, sir.
Okay, it says that, that the copy I have, that you spoke to Lee Spratt and Lee Spratt spoke to you and said he had no contact with me. That's,
That was the day of the trial. He announced he had no contact with you.
okay, is Lee Spratt my, elbow counsel?
He was, yes, sir.
He was my elbow counsel?
Yes, sir.
So he can make, statements on my behalf and testify on my behalf?
Yes.
He can, without my lead?
No, not
Oh.
without your permission.
Okay, so he did that free will?
I guess so.
Okay, you said that you keep a, record of everything filed into this court. Have I ever filed a complaint against you?
No, sir.
Have I
Nothing.
filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Okay, was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that, I back, I want to say last year, and I was released upon out of this court?
Let me think. On July 19th, the day you was here, that Judge Lockern Mash reinstated to your bond. That was the day they dismissed the first one because you gave reason why you did not show up the first time.
Correct.
That was prior to the July 24th.
Correct. And
Yes.
what was the reasoning for that one?
I do not remember what reason you gave.
Could it possibly been some messed up paperwork?
It could have been.
Okay, what about this time? Do you think that could have possibly been?
No, sir. No, sir.
Your Honor, that's all.
Redirect.
No, Judge.
Thank you, Ms. Lewis. You may step down. May she resume her duties if she wants to. You want her at the table with you. Go back to the table and have a seat. State may call your next witness.
Judge, that will be the state's case in chief.
State has rested their proof, Mr. Vaughn. Ladies and gentlemen, if you'll step across the hallway for a moment, let me take up one matter. Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right. Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events and so forth. Likewise, you are not required to testify, and no inference of guilt will arise if you choose not to testify. No one can make you testify if you don't want to testify. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Yes, sir.
All right, then have a seat. Bring the jury back.
Since it does involve the same parties, can we just set both of them in the same week or time period?
Well, it would be nice if I had a whole week to give you. Unfortunately, I have already set my schedule for next year, and I can set the first one on First Federal versus Cunningham, that a day and a half. I can give you 26th and 27th of March. That's the first 2 days back to back that I have open.
Oh, that works for me, Your Honor.
You got something in that same time frame, Your Honor, for the second case?
April 1st and 2nd. Now, I'm setting them with the understanding that those are going to go and they're going to be set for trial If those for some reason settle, I want to make sure that those days, and that I'm alerted so that I can use those days for other things. 2016 CV 380 Sullivan versus Nesbitt, Mr. Osborne and Mr. Massagill.
Honor. Mr. Osborne and I are still working on that case. There's been some property lines walked, some old deeds reviewed, and some settlement negotiations that I need a little bit more time, though. Your Honor, I'd ask that this be moved and reset for the January 6th date if we could get it, but we are moving forward.
January 6th.
Thank you, Your Honor.
2020 CV 289 N. Ray Jordan Blair Woods, Mr. Odle.
Judge, that case can be dismissed.
It has been, or?
It can be.
Wait a minute. Repeat that. It can be or has been?
It has not been, Judge. It was part of a case that was filed sort of out of an abundance of caution. There was a companion wrongful death case as well as an estate, and all matters have been resolved. So that one, I can non-suit it. I can send in an order of non-suit if that's better.
Just enter an order of non-suit. We'll show that.
Yes, sir.
2020 CV 296 Rice versus Rice, Mr. Odle and Mr. Holly.
I'm working on that. Probably have a settlement on it before long. We just need some more time. January 6th, I think.
January 6th.
Yes, sir. Thank you.
2020 CV 362 Marsh versus Kelly.
These are two cases that involve some of the same parties, not all, different counties, different facts, different law. I filed a motion to set the First Federal Bank versus Marlon and Donnie Cunningham matter for trial. It needs to be tried. I'm thinking a day and a half.
And so it is ready to set.
That one is, yes, Your Honor.
Now, that's the First Federal versus Cunningham, which is the
Correct.
second case. What are we doing with Cunningham Construction versus First Federal?
The matter's still pending, Your Honor. Mr. Reagan was taking deposition, and I don't know if he wants to finish those depositions or not, but that could be.
So those are two separate cases involving the same
Entirely.
parties.
Well, there's, First Federal is the same, is the common party to both. One case is an LLC, is the plaintiff against First Federal. The other is First Federal. It's a deficiency action against two individuals, one of whom happens to be the owner of the LLC in the other case.
So they need to be treated separately then?
Yes, Your Honor. Actually, some time ago, exactly that question came before Your Honor. I think the court did rule from the bench that they would be tried separately. That was the
Well,
last time we were
Some
actually.
time ago, that means that I don't remember it. So if you'll just let me know what I said last time, I'm sure it was eloquent, I'm sure it was well-reasoned and intelligent, but if you will let me know what I said, then we'll go from there. But you said I ruled that you would have to try them separately. So you want to go ahead and set the First Federal versus Cunningham, that's docket number 2012 CV 146, and you think it will take a day and a half.
Correct.
And I assume that means that I have to be the one to hear it, since I'm the one who ruled that we're going to have to be heard separately, correct?
It would be greatly appreciated, Your Honor.
So I'm looking for a day and a half. This would be a bench trial, non-jury, right?
Correct, Your Honor.
Your Honor, I filed a motion in response to the show cause order. The court heard a pendente light hearing on September 2nd, 2022, made findings of fact, issued a temporary parenting, a residential schedule, and ordered us to calculate child support based on that schedule. Made a decision as to the,
Is this the case I heard?
it is, Your Honor, and the court made findings of fact about the decision-making and the final decision-making authority. We then swapped discovery. The parties have, I think, co-parented well, but we can't seem to come to an agreement on the issues that I put in my motion. So I think we're down to primary residential parent, how decision-making authority will be allocated, retroactive child support moving forward. So I think it just needs to be set for trial.
There's a lot of discovery needs to take place, but my client doesn't want the divorce, but if they want to proceed, we have to proceed.
All right, then we'll give you a trial date. How long do you expect it to take?
We haven't been to mediation yet,
Well, I'm not going to give you a trial date then until you mediate it, so.
and then
How soon can you mediate?
I think, I'd ask to waive it. I can file a motion to waive it. I don't think mediation's gonna help. I didn't put that specifically in the motion, but
I don't know how things are in the state of Hickman, but over here, we do usually require a mediation, but if there's a good cause, I can waive it. You have any reason to think that mediation would be successful? I don't want to waste the party's time and money.
I understand that, Your Honor. Again, a lot's changed since the Penal hearing. My client's moved closer to the mother. He's hoping that if the case does go forward, to receive equal time, both parties get along well. It seems like if they can get along well, they can probably resolve their case well also. But
You would think,
that would be
you
my.
would think that
request.
would be the case, but it rarely ever is. What about December the 5th? How much have we got that day? We can get them divorced before Christmas. Might save them on Christmas presents anyway. All right, December the 5th would be a good day.
be a good day for me, Your Honor.
That's fine, Your Honor.
All right. December the 5th, and then you think it'll take probably a half a day?
I don't think it, from my side, I don't think it would take an hour and a half, 2 hours. But I don't know if there's anybody else.
Put it
that
down
just-
for 2 to 3 hours.
Mr. Bates could think longer.
And
3 hours.
I'm sure you find lawyers will try to resolve it before then, so.
Thank you, Your Honor.
Thank you, Your Honor.
2022 CV 227 Walton versus Walton. Dismiss, failure to prosecute. 2020. Stanish. 2023 CV 65 Irwin versus Curran. Anyone here on Irwin versus Curran? Dismiss, failure to prosecute. 2023 CV 72 Polk versus Polk. Dismiss, failure to prosecute. 2023 CV 86 Hollis versus Wiggins. Mr. Holly?
Judge, that's case. It's also on the docket today for a motion to approve an accounting that I filed. Mr. Crow finally called or sent an email end of last week, I believe, and allowed me to sign his name with permission. So I hope this takes care of the show cause part. If we can get that accounting approved, and nobody has a problem with it, then I can do a final order closing
All
the
right,
estate
we'll come
very
back to it
quickly.
on the regular docket and pick it up.
All right, thank you.
2023 CV 113 Hunter versus Mathers. Moving to the probate cases, the estate of Susan Ambrose. Mr. Reagan?
Judge, Ms. Ambrose is part of a class action lawsuit that's pending involving faulty implants. And we really need to leave that matter open for a while because it's in federal court, it's a multi-district litigation. So if we could just continue to pass that to the next show cause docket, I'd appreciate
All
it.
right, we'll put it on the January 6th. And again, we'll keep it pending as long as we're just monitoring the status.
Periodically, checks come in, and we just need the estate to be open. Judge, while I'm up here, there was one that was skipped, but I'm assuming the clerk received a notice of non-suit on Hart versus Water Authority of Dixon County. Okay, thank you.
Two 2012 PR 65, the estate of William de Gregorio, and I'm sure that's not right, so.
De Gregorio, I've represented him in another matter.
Say it again.
Now I can't. De Gregorio.
De Gregorio. Mr. Brown, are you involved in this?
I am involved with Ms. Sykes, I think is on Zoom.
Not with us. So what, can you tell me anything about status?
Yes, Your Honor, what the status report shows is that this matter is coming to a conclusion, but there needs to be time to possibly file another income tax return and to determine where the money goes and specifically how to distribute royalties. We have something.
Ms. Sykes, can you hear?
Yes, Your Honor. Yes, Your Honor. Thank you, Nathan, for reporting that to the judge. Yes, Your Honor. All that remains are copyrights and royalties. They have to be transferred to the beneficiaries or the heirs of the intestate estate. And the copyrights are subject to administration agreements by a company that is represented by Casey. His name is Casey Del Casino. And they have to work out how the royalties and the copyrights are going to be administered. Someone has to be administering them. And we have an agreement that's been drafted, and I think we're pretty close to everyone agreeing to the terms of the agreement. There's some issues also as well about another company that owns some copyrights that don't make any money, but we've communicated with everyone, and I think everyone's on the same page now, so I don't anticipate it will take that long. However, the actual transfer of ownership of these things takes time with the company, so that's why I was requesting 6 months. And because the royalties are still being paid to the estate, an estate income tax return will have to be filed again. So I'm thinking that should get me through April. Does it get me through April? What is it? October, November, December, January, February, March. Well, no, it won't get me through April. I probably need 9 months so that Danielle Elks can file the final estate income tax return on behalf of the estate as well.
So how far out are you asking to set it for review?
9 months, Your Honor.
Well, I rotate between 5 counties and my term in Dixon, and none of the other judges do show cause. Wait, now that's a trick question. They will do them if I want them to. So can you put it on somebody's docket 9 months down the road, because I don't have anything in Dixon County for that. I'm here in May and I'm here in September. Those are my set terms anyway, so.
Your Honor, should I prepare an order?
Yeah, but let me give you yes, I'll have you prepare an order, but let's give you a date first.
Okay.
August 26th. And who is that in front of? Judge Turnbow will hear your status on August 26th, if you'll put that in the order.
Yes, Your Honor. Thank you.
All right, thank you.
Thank you.
All right, next case is PR 137, the estate of Okie J. Curley. Mr. Massengill?
Yes, Your Honor, it's my case, and similarly, we're still trying to run down a few documents, looking back for ongoing accounting for a agricultural concern as farm, Your Honor. So with that being said, I think if we could have just a little bit more time, just want to make sure we've got it right. I'd ask for that January 6th date, Your Honor.
January 6th.
Thank you, Your Honor.
2018 PR 14, the estate of Joanna L. Sonia. Mr. Odle.
Judge, I'd ask for January 6th on this one. Court may recall the outstanding issue, the sole outstanding issue on this estate is a piece of property in Puerto Rico.
Oh yeah, we were supposed to go down there and inspect that.
I think that's the delay, Judge. I talked to my client yesterday. I think he is going to try to go down there himself and take care of it. I don't know the timing on that, but that is the only issue that's outstanding to be resolved.
All right, do you have any idea if January the 6th would be long enough?
Judge, I think we should put it on January 6th, and hopefully he can go down there. It's a matter of transferring that property into his name, but we need a local attorney. We've had difficulty.
January 6th. 2019 PR 104, the estate of Janet Brown. Mr. Sanders. Sanders was here yesterday for show cause. Any idea? I'm going to move it to January the 6th, make sure Mr. Sanders is aware of it. 2021 PR 138, the estate of Kenneth Garton. Ms. Roberts.
Oh, Your Honor, I'm sorry, I was trying to think. That is pending. We had a hearing date scheduled. Mr. Ben Regent was representing the decedent, or the grandmother in the case. She died. And now, Mr. Olin Baker is representing him. And we had a hearing probably, I can't remember it, well, Judge Turnbow's term, and it got continued, got bumped. So, I mean, there's ongoing litigation. You have this one, Kenneth Garton is in relation to Doris Garton, who is his mother who died. And there is a lawsuit over tractors and livestock pending. And so that's an ongoing matter that just needs to be.
Any reason to keep it on the show cause docket?
No, I mean, it's an active case. I mean, there's stuff going on. There's an active matter going on. And it's.
We're going to take it off the show cause.
There's an estate case. The estate sued Doris Garton and Kim Judy. And so that's the lawsuit that's pending that has to be resolved before I can close out the estate.
All right. 2022 PR 189, the estate of Annie Biggers.
Judge, the court appointed me administrator of that case. At the time, there was believed to be a sizable checking account at First Bank. I investigated that. It was payable on death, so there was nothing to administer in this estate. However, there's a companion estate for Ms. Biggers' husband that's in litigation, and I prepared a not necessary in the administration of the estate, but I've prepared a affidavit. I've prepared some deeds on this, so I would ask it just be passed to 1/6 so we can close it.
All right, put it on January 6th. All right, take it up.
Morning, Your Honor.
Good morning.
Now, Judge, this is on the docket for show cause. I had filed a notice of non-suit on behalf of petitioner April Hunter, and I have provided an order for such.
I've signed your order, Mr. Atchison.
Thank you, Judge.
All right, let's go ahead and call the regular docket. All right, both of you raise your right hand. Let's place you on the oath. All right, you are Laura Womack Taylor, is that correct?
Yes, sir.
Ms. Taylor, you are wanting to, you filed a petition to adopt Mr. Clifford Edward Taylor, and as an adult adoption, I'm required to ask you some questions, but do you understand that if we pursue this and go forward with it, that it will be as though he is your son, the same as if he was biologically born to you when you were 5 years old, which is what I understand the difference in your ages is, something on that order. But you understand that this will create a parent-child relationship. It will not be in any other kind of form, but it also would mean that he can inherit from you and you can inherit from him, and there will be the familial relationship the same as if he had been your biological son. You understand that? Do you mind my asking why you want to do this?
Well, Your Honor, I kind of did a letter to the court explaining that.
Well, let me look.
Okay.
It may be better for me to read that letter and then.
Ought to be about the second paragraph.
Okay, so you were married to Randall Taylor Sr.,
Right.
and that was Mr. Taylor's father, is that correct? And you want to, he is your stepson, and you want to remove that designation. All right, well, that makes sense. All right, Mr. Taylor, you are legally an adult, I think. Is that, you're over 18? And you understand you have a right to consent to this adoption, and that if you consent it, then your stepmother will no longer be your stepmother. She'll be your legal mother, the same as if she was you were born to her. It's a little unusual because of the closeness in age the two of you have, but I wanted to make sure that both of you understood it. And there are some instances where people would do this adoption for inappropriate purposes, but clearly your letter has clarified that reason. So both of you are in agreement that you want to establish this relationship and that it will be the same as if you were born mother and son. All right. Have you prepared an order? You'll have to prepare an order that grants the adoption. And if you want to, you may want to look at the code on that. There may be a copy of an order that you can get online, but you'll have to submit an order that grants your adoption. And I'm assuming we're not changing your names, since both of your names are Taylor, so. But we'll go ahead and I'll sign that as soon as you can get it one prepared and submit it to the clerk. You don't have to come back to court, but you do have to take it to the clerk's office.
Thank you,
Okay?
Your Honor.
All right. Congratulations.
Thank you.
Thanks, sir.
All right. Well, you skipped over the Marsh versus Kelly.
Order of withdrawal, Your Honor.
All right. So it's Shelton versus Shelton? Is that the one you called?
Yes, Your Honor, counsel had told me he had to, excuse me, counsel told me he had a Zoom something with bankruptcy court and that he was out doing it and he would come back in when he
I'll put it on the
completed it.
second call.
This is my motion to set. This is a divorce. I represent the wife. Mr. Hawley represents the husband. We have completed discovery. We've been to mediation. I think we're just ready for a court date. And I would anticipate
How long do you
about
think it'll take?
half a day.
Got the house involved, the other issues. I would say more towards a day.
Well, I mean, maybe 3/4, but I would hate to think it would take an entire day.
Okay.
That works for me.
Not available on the 6th.
You're not?
No, I'm not available on the 6th. Well, I'm available on the 12th and the 8th. You gave those dates out yesterday for some things. The 8th and the 12th is available. I've got it.
And those, either of those would work for me, Judge. The 12th? That works for me. Submit it, I'll submit an order.
All right, so it's, you're setting it for the 12th?
Yes, Your Honor.
All right.
Thank you, Judge.
Thank you.
Your Honor, this is a parentage action. Prior to taking this up, Ms. Williams is in a divorce action in this court that's been heard in front of Your Honor. It's Williams versus Williams. That is 2024 CV 182. Ms. Duke and I have an agreed order prepared for the court that disestablishes Mr. Williams as the father of the minor child. And what I'd like to do is eventually make that order, once it's signed and entered, an exhibit to this hearing. This hearing will be uncontested.
All right, Ms. Williams, would you raise your right hand? Let's place you under oath.
Yes, ma'am.
You are Emily Chantel Williams.
Yes, sir.
Ms. Williams, I have been handed an agreed order that disestablishes parentage of the child Wilder Gray Williams, born on April the 28th, 2025. By me signing this, it's an agreed order. Your lawyer and the lawyer for Mr. Williams have both signed off on it. But I want to make sure that you understand, by me signing this order, it will establish legally that this child is not Mr. Williams's child. And that's what you acknowledge and agree to, correct?
Yes, sir.
All right, and I have signed the order and it will be marked filed.
Thank you, Your Honor. And in this action 2025 CV 262, Your Honor, is an action to establish parentage and do a legal name change for the minor child Wilder Gray Williams. We served Mr. Williams, Mr. Ethan Williams, through his attorney, Ms. Duke, and
He no longer has standing since
He has
I've
no
now
standing.
terminated his relationship with a child. So.
yes, sir. So, and with us present today is Mr. Wade Stephen Giordano. He
Mr. Giordano, if you'll raise your right hand, let's place you under oath.
Yes, ma'am.
Go ahead.
This is to establish him as the father, Your Honor. Start off calling Ms. Williams. I'll go ahead and take Ms. Williams' testimony first.
All right, that's fine.
You are Emily Chantel Williams, is that correct?
Yes, sir.
All right, and you are the mother of Alder Gray Williams, is that correct?
Yes, sir.
Okay, and is there any father listed on the birth certificate for him?
No, sir.
And Mr. Wade Stephen Giordano, is he the father, the biological father of the father?
Yes, sir.
Have you undergone genetic testing to that effect?
Yes, sir.
Confirmed that 99.999%.
Yes, sir.
And you live with Mr. Giordano?
Yes, sir.
Does the minor child live with Mr. Giordano?
Yes, sir.
And he's held himself out to be the father of the child, correct?
Yes, sir.
All right, and is it your wish, and do you think it's in the best interest of the minor child that his name be changed to Giordano?
Yes, sir.
All right, and you want Mr. Giordano listed as the father on the birth certificate?
Yes, please.
Ms. Williams, Your Honor?
All right. Mr. Giordano, step up to the microphone.
Are you Wade Stephen Giordano?
Yes, sir.
All right, is that Giordano?
Yes, sir.
Okay. And did you hear Ms. Williams' testimony?
I did, yes, sir.
Okay. And does she and the minor child live with you?
Yes, they do.
Have you held yourself out to be the father of this minor child?
Yes, sir.
Okay. And were you there present for the birth?
Yes, sir.
And is it your wish to be declared legally the father of the minor child?
Yes, sir.
And you want your name listed on the birth certificate as the father?
Yes, please.
Okay. And are you doing this, or either of you doing this to avoid creditors or anything like that? Because you are the father and you want that reflected on the birth certificate?
It's because I'm the father and I want to reflect it.
Okay.
Yes, sir.
Those are my questions.
All right, Mr. Giordano, is that how you pronounce it?
Yes, sir.
You understand that by entering into this agreement that you are formally establishing your paternity and this will be your child from henceforth legally and every other way, so.
Yes, Your
You
Honor.
understand you're assuming that responsibility, and attached to that responsibility is a responsibility of support as well as the rights and duty to exercise visitation or custody of the child. You understand all of that?
Yes, Your Honor.
All right, you have an order?
I do, Your Honor, and Ms. Duke has signed that order as well.
All right, I've signed your order. Thank you.
Thank you, Your Honor.
Thank you.
How's your summary judgment thing going?
Anyone here for Horizon Medical Center? No one here to prosecute the claim. The exception is granted, Mr. Mize.
Thank you, Your Honor. I'll draft the order.
All right. All right. Next case.
Judge, that's an estate. Cheryl Wiggins behind me here is a personal representative. It's been a fairly contentious situation throughout. You've heard some testimony on it, not a lot.
Straighten the microphone.
We're down to having the accounting approved. Lynn Coffenberry was appointed as the guardian ad litem. I had tried to put an accounting together and send it out to everyone. Ms. Coffenberry agreed with it. Mr. Crow was requesting his client to receive attorney's fees. We kind of objected to that. And then when I filed the motion last week, he sent an email saying that I could sign his name with permission. I filed that yesterday at the clerk's office. So you should have a accounting there with an agreed order where everybody has approved it. Pending your Honor's approval, I will do a petition to close the estate. You'll notice in the blanks there, there's like June something for the checks for the guardian ad litem and my attorney's fees and the fees and the cost with the estate. But that was because I was trying to get, at that time, everything circulated and he was having that request. So with that request being gone, I'm asking the court to approve that accounting so we can close the estate. Mr. Trice did an outstanding job selling that property too, by the way.
All right. And you had a lockbox at First Federal Vanderbilt Bank that had a paperclip in it.
I have the original, I have that paperclip still in office, so if anybody wants it, we can divide it up.
How is
however.
that paperclip passing? To whom? Is that going to anyone in particular under the estate?
Well, I think it would have to be divided up between his son and his spouse here, so if we need to cut that up, I guess we could. But no, I still have the original paperclip. And we had to go twice to the bank. We had to drill the lockbox. It was that kind of, everybody's recording it, and we opened it up, and there's
Yeah, I've been there and done that. Ms. Roberts and I had a case many years ago where we sat at the Van Leer Bank and went through a lockbox after a judge suspended a hearing, and it ended up, it was originally supposed to be about $10,000 in it, and I think it ended up being like $40,000 in cash. But the clerk, all in small bills. We had Ms. Roberts on one side of the table, me on the other, and the clerk and master Patsy Brooks sitting there, all of us counting stacks of money and then trying to make sure we had the correct amount. It was an interesting day.
As the note that my client had it in a false name and
Yeah,
and
Ms.
potentially.
Roberts' client had rented the box under
Oh,
a
yeah.
false
Money.
or assumed name, and that we elicited from him reluctantly in cross-examination. Judge Burt stopped the hearing and ordered us to go that moment to the bank at Van Leer and open the lockbox, and all three of us sat and counted money.
This was the brother of Mr. Hollis, and I understand that. He wanted to see what was in it, but everybody was looking for a will. You know, he had a will. I know he had a will. It's in the lockbox.
We had a lockbox, he just didn't have anything but a paperclip in there, so.
Yeah, well, they left, and then I knew it was coming. He came back and wanted to see the card of who all had been in the lockbox, and all informed the court. The only notation they had on that was Mr. Hollis, the deceased, got into the lockbox when he opened it up that day, the same day he opened it up. He was written down as being in it, and then nobody else had any access to it, or nobody else ever opened it up for years.
All right, then I will be glad to approve your final accounting since everyone signed off on it, if you'll submit an order.
I will, Judge. I'll close it out fairly quickly, so.